In this video I'm going to take a look at what the Court of Appeal decided in relation to the John Waters and Gemma O'Doherty challenge to the constitutionality of laws introduced in the Irish state by the government in response to the COVID-19 pandemic. You may recall, and if you're on my website or my YouTube channel, you'll know that last year the High Court had refused them permission to bring a judicial review application to challenge the constitutionality. They then, in their response, refused or appealed the decision to the Court of Appeal. The three-person Court of Appeal said that the decision by the High Court was the correct one, and that even though the case was controversial and tendentious, no serious legal issue that would justify the granting of permission to bring the judicial review had been raised. The applicants, he said, claimed to know better than the government and the Oireachtas, and they dismissed internal and international advice concerning the pandemic available to the government. He said their proceedings failed to raise issues of substance. They had chosen rhetoric over substance and fiction and distortion over fact, and failed to meet the threshold of establishing an arguable case. Last year, as I say, the High Court had made a similar decision to the challenge by Gemma O'Doherty and John Waters. They had claimed that the laws and the manner in which they were enacted were unconstitutional, and they infringed upon a person's right to travel, bodily integrity, family, the status of the family in the Constitution, and so forth. They argued that it was an unprecedented suspension of constitutional rights. There was also talk about Nazi Germany and so on and so forth. That sort of rhetoric didn't cut the mustard, didn't really butter any parsnips with the High Court, and the Court of Appeal has gone along the same lines. So they had not provided any expert evidence or facts to support their views. The laws were disproportionate and unconstitutional, and the manner in which the Oireachtas had introduced the laws was not something that a court could interfere with. And that was the feeling of, or the judgment of, the High Court. They then, as I say, appealed it to the Court of Appeal, and in their submissions to the Appeal Court, Gemma O'Doherty and Mr. Waters argued that the High Court's decision was wrong and that it did not get a fair hearing in the lower courts. Mr. Waters argued in the Court of Appeal that the High Court decision should be set aside because it was deeply tainted. He said that the laws introduced were made off the hoof. However, the Court of Appeal wasn't accepting that, and the Court of Appeal essentially said that they were engaging in chosen rhetoric over substance and fiction and distortion over fact. And one of the senior counsel in the case had referred to their submissions as Bermuda Triangle stuff. There's another issue to do important here, and that is that the very method by which they sought to challenge these measures taken by the government should not have proceeded by way of judicial review. It should have been by oral hearing and oral evidence and so on. But the difficulty there, presumably for Gemma O'Doherty and John Waters, was that they really didn't have the evidence that would leave them in a position to be able to leave themselves open to oral evidence and so on and so forth, and indeed any evidence, because both the High Court now at this stage and the Court of Appeal have basically said that they are engaging in rhetoric over facts, in highfalutin and high-flown speeches rather than substance, and the Court of Appeal has, say, thrown out their case. The High Court had previously thrown out their case, and the High Court had previously awarded costs against them as well. On my channel, and you'll see if you wish to have a look at the High Court decision and the High Court decision in respect of costs of two other videos there, which you may be interested in. If you find this video useful, I would appreciate if you gave it the thumbs up down below. Thanks for watching.